Welcome to week 6, self-evaluation of unfair dismissals. This week is basically reflection week. You will be required to self-evaluate unfair dismissals with regard to everything that you have learned or gained knowledge of in the past 5 weeks. The purpose of this week is designed to help you to think about which concepts were easy for you to understand, which concepts may have been complicated, in terms of what you learned and how they were connected to other concepts that you had learned. During this week, you can identify which concepts were also difficult or challenging for you and what made them difficult. Good luck with this week. The right not to be unfairly dismissed. Employees have rights under the Labor Relations Act not to be unfairly dismissed. In this context, dismissal means not just termination by the employer, but also cases where an employee is on a fixed-term contract and reasonably expects the employer to renew the contract on the same or similar terms, but the employer offers to renew it on less favorable terms or does not renew it at all. An employee on a fixed-term contract reasonably expected the employer to retain the employee on an indefinite basis on the same or similar terms as the fixed-term contract, but the employer offers to retain the employee on less favorable terms or does not offer to retain the employee at all. The employer refuses to allow an employee to resume work after maternity leave. An employer who has dismissed a number of employees for the same or similar reasons offers to re-employ one or more of them, but refuses to re-employ another. An employee terminates employment with or without notice because the employer made continued employment intolerable for the employee. An employee terminates employment with or without notice, but the new employer, after a business transfer, provides the employee with conditions or circumstances at work that are substantially less favorable to the employee than those provided by the employer. And those are basically the different types of dismissals that we have learned in terms of an unfair dismissal context. Unfair dismissals. Dismissals for certain reasons are automatically unfair, while other dismissals are unfair if the employer fails to prove that. The reason for dismissal is a fair one related to the employee's conduct or capacity, or based on the employer's operational requirements. The dismissal was effected in accordance with a fair procedure. In assessing whether or not the reason for a dismissal was effected in accordance with a fair procedure, the Code of Good Practice on Dismissals, as set out in the schedule to the LRA, must be taken into account. Employers must generally give employees notice of dismissal, whatever the reason for the termination is. And you are also required to bear in mind the different reasons that must be provided by the employer for automatically unfair dismissals. Types of unfair dismissals. In the previous weeks, you have learned about the different types of unfair dismissals. Firstly, with regards to misconduct, all employers should adopt disciplinary rules that establish the standard of conduct required of employees. These rules must create certainty and consistency in the application of discipline, and standards of conduct must be clear and made available to employees in an easily understandable way. The purpose of discipline is to enable employees to know and understand what standards are required of them. Efforts should be made to correct employees' behavior through a system of graduated disciplinary measures, such as counseling and warnings, prior to any dismissal process being taken. Formal procedures need not be invoked every time a rule is broken or a standard is not met, and employers should use informal advice and correction to deal with minor violations of work discipline. Repeated misconduct. warrants warnings, which may be graded according to the degree of severity. More serious infringements or repeated misconduct may call for a final warning or other action short of dismissal. Dismissal should be reversed for cases of serious misconduct or repeated offences. Employers should keep records for each employee specifying the nature of any disciplinary transgressions, the actions taken by the employer, and the reasons for them. With regards to operational requirements, we have learned that when an employer contemplates dismissing one or more employees for reasons based on its operational requirements, the employer must consult any party, for example, a trade union, that is required to consult by an applicable or collective agreement. If there is no collective agreement that requires consultation, the employer must consult any workplace forum that covers the employees or employee likely to be affected. In all cases, consultation requires engagement in a meaningful joint consensus-seeking process in relation to appropriate measures to avoid the dismissal, minimize their number, change their timing, and mitigate their adverse effects, the method for selecting the employees to be dismissed, and the severance pay for dismissed employees should also be taken into account. Through the cases, in determining unfair dismissal disputes, we have learned that adjudicators have the task of striking the balance between employer and employee interests. As we have seen in the case of Sedumo versus Rustenburg Platinum Mines Limited of 2007. However, the determination of fairness is not always a simple task. This is the challenge that presented itself in EOH Abantu versus CCMA 2019, the Labour Appeal Court decision. In this case, an employee had been charged with misconduct, and it was unquestionable that he had committed an act of misconduct. However, the employer classified the misconduct as one involving dishonesty, whereas he committed and was found guilty of gross negligence. The substantive fairness of the dismissal was challenged on this basis. The case essentially came down to whether the incorrect framing of the allegations was unduly prejudicial towards the employee, such that the only fair decision was to exonerate him, despite his commission of misconduct. In Nihau versus University of Cape Town, Justice Ngobo expressed himself as follows regarding fair labor practices and in particular the fairness concept. Our Constitution is unique in constitutionalizing the right to fair labor practice, but the concept is not defined in the Constitution. The concept of fair labor practice is incapable of precise definition. This problem is confounded by the tension between the interests of the workers and the interests of the employers that is inherent in labor relations. Indeed, what is fair depends upon the circumstances of a particular case and essentially involves a value judgment. It is therefore neither necessary nor desirable to define this concept. The concept of fair labor practice must be given content by the legislature and thereafter left to gather meaning in the first instance from the specialist tribunals, including the Labour Appeal Court and the Labour Court. These courts and tribunals are responsible for overseeing the interpretation and the application of the 1995 LRA, a statute, as we know, which was enacted to give effect to Section 23 of the Constitution. In giving content to this concept, the courts and tribunals had sought guidance from domestic and international experience. Domestic experience is reflected both in the equity-based jurisprudence generated by the unfair labor practice provision of the LRA, as well as the codification of unfair labor practices in the LRA. International experience is reflected in the conventions and recommendations of the International Labour Organization, Of course, other comparable foreign instruments have also been considered. Determining fairness. The determination of the fairness of a labor practice can occur in one of four situations. It is therefore important to identify the type of situation in order to correctly apply the right to fair labor practices. Firstly, no legislative provision is in existence and the courts develop the common law. Due to the fact that no legislation regulating the fairness of specific situations was in existence at the time, the courts will have to develop the equity-based jurisprudence. The unfair labor practice must firstly be identified, and the balance between the interests of the employer and the employee must be found. Secondly, legislation affording discretion to tribunals or courts to determine the fairness of a labor practice. Legislation usually identifies the different labor practices, but the determination of fairness thereof is left to the discretion of specialist bodies. Examples of these practices are dismissals, employment discrimination, reorganization of employment, and discipline. The courts and tribunals must then give content to the practices in order to interpret and apply the legislation. In applying the discretion, regard must be had to the legislation itself, previously decided case law, and international instruments. Thirdly, legislation is in existence and expresses the fairness of the provision itself. Legislation must be tested and analyzed by the courts to determine whether fairness is given expression to. And fourthly, legislation is in existence and allows for various mechanisms, including collective bargaining, to determine the fairness of a practice. This situation mainly addresses underlying disputes of interest. Such a dispute is usually regulated by legislation, but they are also usually left without any arbitration-based remedy. Since the fairness of these disputes usually can't be determined by arbitration, two other mechanisms fulfill this role: collective bargaining and the standards of legislation. The fairness of these disputes must be determined by the mechanisms that have been designed itself. Otherwise, the Constitutional Court will become an appeal court on every claim of fairness, as we may have seen in some of the cases. Also, the most collective issues come into play. Resort should be taken to sections 23(2) and 23(6) of the Constitution. Conclusion. Fairness is a concept that has drawn attention not only since the unfairness of labor practices in South Africa has been realized, but since the beginning of time. In attempting to comprehend the meaning of this concept, attention should therefore be divided to the unfairness complained of, the views of the philosophers, the previous industrial court's perception and decisions on fairness, contemporary views, and future predicaments. Determining the fairness of a labor practice should not be done according to a value judgment made by a court, as this would lead to much uncertainty. In Concord Plastics Pty Limited versus National Union of Metal Workers, it was held that in determining whether a particular practice constitutes an unfair practice, the court passes moral judgment. Therefore, a statutory definition of an unfair labor practice must be interpreted and applied in accordance with the spirit, purport, and objects of the fundamental rights guaranteed by the Constitution. It is not certain what type of value judgment will ensure fairness, and it is also uncertain how it should be done. Furthermore, the content and standard of such a value judgment is uncertain. As we have seen, a labor practice will only be regarded as fair if it bears both an economic rationale and also proves to be legitimate. It is suggested that fairness is determined by balancing the respective interests of parties in any given situation. Unfortunately, what is also true is that fairness for everyone would be possible only if everyone's interests were the same.